Hello everyone, welcome to another episode of The Letter of the Law here through Bloomsbury Radio. We are speaking today with Chun Wong, partner at the dispute resolution team over at Hodge Jones and Allen Solicitors just down the road from us. This show will also be distributed across Hodge Jones and Allen Solicitors' own podcast, the London Legal Podcast. Hello Chun, how are you doing today?
Hello everybody, I'm very well, thank you very much.
Now, Chun, could you tell us a bit about your role within HJA, Hodge Jones and Allen Solicitors, how long you've been with the firm, exactly what you do day to day?
So, I am a partner in the dispute resolution team. In fact, I head up the dispute resolution team at Hodge Jones and Allen. I started with Hodge Jones and Allen in 2007. And so dispute resolution covers a wide range of civil disputes, one of which is contentious probate.
Excellent. And Hodge Jones and Allen Solicitors, as I mentioned, not far from where we're actually recording today. And it's a firm that's been around for quite a while, hasn't it? Could you give us an idea about, the firm, its mission statement, the sort of work it does?
So the firm started in 1977, that's 48 years ago, with our three founding partners, Patrick Allen, Henry Hodge and Peter Jones. So it's grown from the three of them, and we now have over 250 staff. So they started a firm because they wanted to help people. They wanted to fight for people's rights. And that ethos is as strong today as it was then. So we have about 8 different teams in the firm who all tie into that ethos. Excellent.
Now we're here today to talk about the law clinic with Bloomsbury Institute London. Can you talk a bit about how this collaboration got off the ground between Bloomsbury and Hodge Jones and Allen Solicitors, the sort of initial discussions you had?
So the partnership started in March 2025. Daniel Denton, who is a partner in our personal injury team, initially approached Bloomsbury Institute and asked if they would want to partner with them to run a personal injury clinic. And they were very interested, and so it's been up and running. And then Dan approached me about whether we would also want to extend that to a contentious probate clinic, and we were very keen, and Bloomsbury were very keen, and so we have recently set up the contested probate clinic as well.
Excellent. So many members of the public will be listening to us today, as well as students. Could you talk about sort of the collective aims of this partnership, how both those audiences can benefit from this personal clinic?
So firstly, we want to improve access to justice by providing free, confidential legal advice to members of the public, as I said, on a range of issues, including personal injury and contentious probate, particularly because in the contentious probate arena, you can't get legal aid anymore since 2012. Secondly, it's to offer students the opportunity to gain practical and hands-on experience to enhance their employability, exposing them to real-life cases and clients so that they can use those skills in their careers. And ultimately also to have a positive impact on the local community. Hodge Jones and Allen are very local to Bloomsbury Institute, so we want to collectively give back to the community.
Great. Now, before we dive into the mechanics about how this clinic works, the term contested probate, for those listening who sort of want to demystify what the word probate means and what contested probate covers, could you speak a little about that?
So contested probate covers claims or cases where somebody's died effectively. So there is a disagreement about somebody's estate following their death.
Thank you, Chun. Now, this is a remote clinic. Could you talk about exactly how this remote contested probate clinic works?
So a member of the public would complete an inquiry form. Then a student would arrange a remote meeting with the client. And during that meeting, they would get free legal advice on any contested probate claim within scope. After that meeting, the student will assist with drafting a letter of advice, which is checked by a qualified member of staff at Hodge Jones and Allen, and then that will be sent to the client.
Thank you. And what types of cases are covered by this clinic?
So contested probate covers quite a wide range of issues. So just to give you a few examples of that, typically they might be challenging a will, or they might be seeking to make what's known as an Inheritance Act claim. They might be seeking advice about removing a personal representative or trustee, or to bring a claim because they think that they've breached their duties during the administration of the estate. They might be seeking an account or an explanation of the way that the estate has been administered by the personal representatives. Also, we might get inquiries where the client is actually acting on behalf of the estate. So they want to either bring a claim or defend a claim on behalf of the estate.
Thank you, Chun. Now, you spoke a little earlier about the benefits of this collaborative partnership. Let's take two audiences here, the members of the public and the students. Let's start with members of the public who are listening to this. Could you reiterate exactly what the benefits are to a member of the public getting in touch with us to make an inquiry?
Well, the primary benefit for members of public is that they get free legal advice from a specialist solicitor, completely free, no obligation, it's confidential, and they may not have been able to access that in a normal way, as I said, because there is no longer legal aid in this type of area, or the fees of a solicitor may be prohibitive. For the students, obviously it allows them to promote the clinic, which is a key skill. It allows them to develop soft skills such as interviewing, communications, drafting. So those are all relevant skills that they can put on their CV, which a future employer would like to see.
Okay, thank you. Now, returning to contested probate itself and the sort of work that yourself and this clinic will cover, could you talk about some of the different reasons one might contest a will?
So, to start off with, a will has to be prepared in a certain way for it to be legally valid. It needs to be in writing, it must be signed by the deceased, and it has to be witnessed by two independent adults in the presence of the deceased. So in order to challenge the validity of a will, one of the grounds might be that those technicalities have not been complied with. So for example, the witnesses didn't actually witness the deceased signing the will, or there may be arguments that the deceased didn't actually know what they were signing because, for example, English isn't their first language and the will was never translated to them. A common ground that a will might be set aside is that the deceased didn't have what we call testamentary capacity to understand what they were signing and the implications of the will, or that there was forgery or fraud involved. So, for example, they didn't actually sign the will and somebody else has forged their signature. And then finally, another ground would be undue influence. So they were influenced to execute a will which they wouldn't otherwise have done under their free will.
Thank you, Chun. So if a member of the public makes an initial inquiry through the website, they input the inquiry form and get in touch, and you've looked at the circumstances of what's happened to them, and you think that there's potentially a good case there, what would be the next step from the perspective of that member of the public?
So after they have had their free clinic session with Bloomsbury, if they wanted to take the matter further and we felt that there were reasonable prospects, we would advise the client on funding options, so how they're going to fund their case beyond the free session with Bloomsbury, and also an estimate of costs to take the case further, for example, the first stage. If they are content with those options and they're happy to proceed, then Hodge Jones and Allen would open a file for them. They would then get a client care letter which sets out our terms and conditions and how the case is going to be run, who the solicitor is going to be, and the next steps going forward with Hodge Jones and Allen.
And what would those next steps be if you start working with that client and they wish to contest a will?
So once they've signed on with Hodge Jones and Allen and we've got a client care retainer in place, then we would want to arrange a meeting with the client so that we can take much more detailed instructions, because the initial session with Bloomsbury is limited to 30 minutes. So we want a more extensive meeting with the client. In preparation for that meeting, we would want the client to bring along and collate any relevant documentation they might have. Once we've had the meeting and we have reviewed their documentation, then usually the next step we would then send them a much more detailed letter of advice, or we might draft the initial letter to the other side, setting out the client's case and what they are seeking in terms of remedies.
And the world of contested probate, like other areas of law, is often and many times subject to limitation periods and time limits. Could you talk about the kind of time limits involved for different types of contested probate claims? And for those who aren't familiar with the term limitation period, could you speak to that as well, please?
Yeah, so starting off with limitation. So a limitation date is the deadline in which you have to have issued a claim in court in relation to your claim. And sometimes if you miss that date, then you may be prevented from bringing a claim. So it's very important to understand the limitation dates which applies to your type of case. Now, contested probate claims, like most civil claims, is subject to a 6-year limitation period. There are, however, exceptions. One of the main exceptions to that is if you are looking to bring what's known as an Inheritance Act claim. So an Inheritance Act claim is where you fall into a certain class of claimants and there has been no reasonable financial provision made for you, either in a will or under the rules of intestacy, and you think that you should get more from the estate. Now, those type of cases are subject to a very, very short limitation period. It's only 6 months from the date that probate was granted. So it's very important that you find out whether probate has or hasn't been granted and what that date is, because you only then have 6 months to bring a claim.
Thank you. So we're speaking with Chun Wong from Hodge Jones and Allen Solicitors today. Chun is a partner in the dispute resolution team, and we're talking about contested probate, specifically the Contested Probate Law Clinic that we are working with in conjunction with Bloomsbury Institute London. Chun, we're talking about potentially taking the start of case with a client, and as things kick off and you're collating all of this information, are there any other steps that you take at the start of a case?
So as we've touched upon already, the client will need to collate all the evidence that they do have, or maybe they don't even have, so they may have to go away and conduct some further investigations. They may have to obtain the will file, if there was a will, from the will drafters. They may need to get medical evidence either for the deceased or for themselves. They might need to obtain financial information. And in addition to that evidence, they may have to contact witnesses. So, for example, the witnesses who who witnessed a deceased signing the will. So they may need to take some evidence from them. In the meantime, while you are putting together all this evidence and before any contact may have been made with the other side, there are some protective measures that a client may want to take. So, for example, they might need to work out whether a grant of probate's already been obtained, and in order to do that, you can conduct what's known as a standing search at the probate registry. That lasts for 6 months. So if in that 6-month period somebody applies for a grant of probate, you will be sent a copy, as I said, because there are certain time limits which runs from the date that the grant of probate has been obtained. Now, if you are looking to challenge a will, and in fact you don't want anybody to obtain probate, then you can place what's called a caveat on the estate. And again, you apply to the probate registry, and that caveat will last for 6 months, and it's renewable at 6 monthly intervals. If there is a property which is part of the estate and you want to be alerted to any dealings with that property, you can place a land registry alert at the land registry. If you are concerned about dissipation of assets in the estate, you can make initial contact with the other side and ask that they don't take any action to dissipate the assets pending agreement between the parties or an order from the court. Now, if they won't agree to that, then you will need to consider whether you need to take some urgent action, such as obtaining an injunction to prevent the estate assets being dissipated.
And just to be clear, that if a member of the public is listening to this and thinking, oh, that's a lot of work to do, they are assisted by a solicitor throughout this process, are they not?
Yes, so if they have instructed Hodge, Jones and Allen, then most of those steps will be taken by the solicitor acting for them. So I know it sounds very overwhelming in terms of what needs to be done, but your solicitor will guide you every step of the way. They will give you clear advice, updates about what is going on with your case, and obviously answer any queries you have.
And about court, a lot of people may be worried about going to court, may be worried about adversarial processes with family, etc. Will a client be always required to go to court?
Not necessarily, it depends, but in my experience, 9 out of 10 cases never make it to court because the court process is very expensive and takes a very long time. The court is understaffed and under-resourced, so cases will typically take at least 12 months to be listed and heard at a final hearing. So ideally, with your solicitor's assistance, you would try and resolve your case either before proceedings are issued or ideally before you get to a final hearing. And in fact, the courts will penalise parties who have not taken steps to try and resolve their dispute in some form of alternative dispute resolution, such as mediation or negotiations.
We do hear a lot about alternative dispute resolution, or ADR, and mediation. Could you just provide a sort of snapshot of how that process works?
So ADR can take a lot of forms. As I mentioned, it can be quite informal. It could just be negotiations between the parties via their solicitors in terms of trying to narrow the issues or achieve settlement. It can be in a much more formal context, such as mediation, which would involve an independent third-party mediator, and usually the parties all come together for a day to try and again narrow the issues or attempt to agree terms of settlement.
Thank you. Now we're winding down our conversation. We're here with Chun Wong, partner in the dispute resolution team of Hodge, Jones and Allen Solicitors, speaking about the Contested Probate Legal Clinic in conjunction with Bloomsbury Institute London. Now, if anyone's listening to this, Chun, whether it be a member of the public, a student, or student thinking about their own family perhaps, what advice would you give to anybody who is thinking of making a contested probate inquiry?
I would say get in touch. There's no obligation. And obviously the clinic is free, offering pro bono advice, and we can assess your case, give you the advice, and obviously signpost you going forward as well.
Thank you. Now, Chun will be back, no doubt, in a future episode, perhaps with one of her colleagues. There are many other shows to come with Hon Jones and Allen Solicitors, which will be featuring other teams. But for today, Chun, could you talk about how an individual can make an inquiry through the website, or whether it's via email or through a telephone number?
So if you would like to learn more about the Bloomsbury Institute Law Clinic, then please visit the website, or you can look up Bloomsbury Law Clinic. If you would like to make an inquiry, then you can also call us on 03300 294 446, or email us at billradio, that's BILRADIO at hja.net.
Thank you. So just to reiterate that, if you're online, whether on your mobile or whether you're on your desktop or your tablet even, go to the Bloomsbury Institute London website, and through the search engine function, please look up Bloomsbury Law Clinic. You'll then find all the details about the Contested Probate Law Clinic, including the inquiry form where you can get in touch. And as Chun said, if you've got your phone handy and you just want to find out more, please call 03300 294 446. And if it's email that you prefer to use, it's BIL radio, all one word, billradio at hja.net. And Chun, we can find out more about you and the work you do on the HJA website, isn't that correct?
That's correct. So if you want to know more about myself or my team, or the cases that dispute resolution deal with, including contentious probate cases, then you can visit our website, which is www.hja.net, and search for my name, or even search for contentious probate.
Thank you. And just to reiterate, if you are going to do that, to find Chun Wong, Chun's name is spelt CHUN, her surname WONG, and you should be able to find out everything about Chun and her department and the work they do. So goodbye for now, and we look forward to speaking with you on the next episode of The Letter of the Law. Thank you very much, Chun Wong from Hon Jones and Allen Solicitors.
Thank you.